appeal of D. Menzies against Oakwood Solicitors Ltd.
Yes. If it pleases your lordships, my lords, I appear with Miss McGungle in this matter for Mr. Menzies, the former client of Oakwood Solicitors, the respondent, represented by my learned friends, Mr. Ralph and Miss Bedford. My lords, as your lordships will be aware, this is my client's appeal against the decision of the Court of Appeal, which in turn allowed an appeal against the decision of Mr. Justice Bourne, who in turn had allowed an appeal against the decision of Costs Judge Rowley.
Yes.
All of which relates to a single question, which was whether my client is entitled to an assessment by a cost judge of a bill of costs delivered to him by his solicitors. And the Lords gave permission to appeal on a single issue in relation to that, which is the question of what the word payment means within its specific context in Section 70, and we will probably see Section 71 of the Solicitors Act of 1974. My Lords, so as your Lordships will be aware from the written cases, the statement of facts and issues and the judgments, the cost judge decided that my client would have been entitled to that assessment, but for a single point, namely that the bill delivered had been paid within the construction of Section 70, subsection 4 of the 1974 Act, more than 12 months before the date of the application for assessment. As your Lordships will also have seen, but for that single point, the cost judge accepted that even though the application was made more than 12 months after the delivery of the bill, that there were sufficient special circumstances, to use the term of art, to warrant my client having an assessment despite the passage of time. So it is a single point, the fact of payment based on the construction of the Act, that was the knockout blow. My Lords, I won't take you, because I know you will have already considered it, back to what those special circumstances were, but your Lordships will no doubt have seen what the cost judge considered justified that assessment in any event,
yes.
And I consider it required. So, my Lord,
the particular special circumstances found by the cost judge in this case really have no real bearing, do they, on the points of interpretation which we have to deal with?
They do not, Lord, no, which is why I'm not delaying by taking your Lordship
Indeed.
to them. They turn on essentially inadequacies. I think the cost judge described the documentation sent to my client as some of the most impenetrable that he had come across in his experience as a cost judge. But that bears purely on the question of whether there are special circumstances. I entirely accept that if the Court of Appeal is correct on its construction of the statute, it is a knockout blow. Section 70 of the 1974 Act, Section 70, subsection 4, operates as a guillotine. It comes down, and it comes down sharply. And so if that construction is correct, those special circumstances are naught to my client's benefit.
Once you've done your prep, the points at issue are really quite short ones.
They are, my Lord, quite short ones indeed.
So don't feel embarrassed if you take less than your allotted time.
Well, Lord, I'll endeavour to do so if I don't promise to do so.
No need to promise. And after all, you have to make an allowance for injury time.
Well, I hope there won't be too many injuries, but perhaps I'll see how I go. So, as your Lordship's indicated, this appeal really does turn on that single, narrow, and hopefully quite short point, which is what does payment mean within its specific context within the Act. My client's case, as your Lordship knows, is that there was not payment until, firstly, a bill had been delivered, and secondly, my client assented to the specific amount of that bill. The respondent's case is that payment had been effected by virtue of a general agreement that the solicitor could use monies received on the client's behalf to pay their costs, and then completed by the delivery of a bill. And it's the delivery rather than any assent to the bill which forms the core difference between the parties.
You probably know much better than me, I'm speaking to counsel generally, how common in solicitors' retainers a provision for deduction from client account of an amount shown on a bill after delivery of the bill is.
Yes.
My perhaps out-of-date expectation is it's probably very common.
My Lord, I think that expectation is probably up to date. Certainly in the context of personal injury solicitors, I think it's almost standard. I think it was probably formed, I'd have to check, but when it existed, as your lordship may know, there used to be a standard law society conditional fee agreement which was drafted for the assistance of solicitors. They could use it or they could model something from it themselves. And I think, although I'd have to check, that such a term formed part of the standard conditions under that. So certainly amongst personal injury solicitors, I imagine it is, if not ubiquitous, very common.
And we're not here concerned with just litigation matters.
No, my lord, we're not.
Am I right to think that if respondents are right, whenever an agreement with a solicitor has such a clause in it, there would never be any question of whether there were special circumstances or not? You'd never get to that provision?
My lord, I think that is correct, yes, because there would be, by delivery of the bill, there would have been payment. So if the client makes the application within 1 month, they would... sorry, no, my lord, that's not quite right. So if the client makes the application within 1 month, they would have an automatic right to assessment. If they made the application within 12 months, then even if there has been payment, they would be entitled to an assessment if there were special circumstances. It's the 12 months that affects the guillotine, the passage of 12 months from payment to the time of the application that brings the guillotine into play. And that, my lord, is section 70, subsection 4, which I'll take you to shortly. So, my lord, as I say, just to put our case in a nutshell, because, of course, what both parties are inviting this court to do, we bring the appeal, but, of course, both parties are inviting the court to determine this issue conclusively, is to construe that word and essentially to tell us what it means. And it's important, therefore, just to be clear as to, or to attempt to be clear as to what we say it means in comparison to the respondents. We say it means that in the context of the Act, payment is the transfer of monies in the amount of a received bill with the consent of the client. The term that your lordships will have seen referred to in the written cases and in the authorities relating to the predecessors of this particular statute is a settlement of account. And whilst we continue to adopt that, I think it's right to say that the phrase settlement of account in isolation probably itself begs for a little further of explanation as to what is meant. But what we say is provision of an account, so in other words, the receipt of a bill seeking a specific sum, and the settlement of account by the client agreeing to the transfer of monies in the amount that is sought, or should it be otherwise, in some other compromised sum, some other specific sum.
So when you say with the consent of the client, you don't just mean that the transfer is with the consent of the client, but the amount is with the consent of the client.
Lord, yes.
I'm not sure the little helpful modern version of settlement of account that you've given us really quite makes that clear. Well, Lord, but I think that's what you're saying.
It is what we are saying, a very specified sum. So a specified sum is requested, and the client either agrees to the transfer of monies in that specified sum, or, of course, there would always be the possibility that the parties would then sit down and agree to compromise it in a lesser sum, and the transfer is of a lesser sum. But it's the important point is the receipt of a request for a specified sum and the agreement to a transfer of that specified sum. And I use the term transfer because, of course, payment could be effected in the old-fashioned way by the client signing a cheque or something of that kind, or agreeing to the solicitor using monies that they already have in their possession.
So if we look at paragraph 3 of your case, where you put your case in a nutshell, that remains how you put it, the last sentence of paragraph 3.
Lord, yes. So the reference there to specific amount.
Yeah. Agreement to the specific amount.
Lord, yes, that is exactly how we put it.
And that's what you say settlement of account in the language of the old cases means.
Lord, yes, that's what we say when we look at it, and we will come, subject to your Lordship's agreement, to look at some of those cases relatively briefly. But we say what we will see when we look at them is that is in essence what those cases are predicated on, what they require, is the provision to the client of a demand for a specific sum, and then an agreement to the transfer of monies in that specific sum.
Okay,
needn't even be any transfer at that stage. Just the use of money. It could be a use of money that the solicitor already holds.
My Lord, yes, I use the term transfer to encompass that. So it would be, there would still in effect be a transfer. It would be the solicitor essentially internally transferring the monies from one account to another.
From client account to office account.
The obvious one being from client account to office account, yes.
So from a trust account to an account which the solicitors have beneficially.
Indeed so. So, my Lord, the fundamental difference, and I'm sure your Lordships already have it, between our position and the Respondent's position, and that adopted by the Court of Appeal. The Respondent's position, as your Lordships will have seen from their written case, is that payment requires a transfer of money, and the term they use is in satisfaction of a bill, with the knowledge and consent of the payer. Now we say that further definition by the respondents themselves of what payment is, in fact, probably requires a degree of unpacking to see what it means. It's unpacked to some extent by the respondents in their written case, where they say it engages with the notion of the transfer of money or its equivalent in satisfaction with the knowledge, in satisfaction of a bill with the knowledge and consent of the payer.
Which paragraph is that, please?
Lord, that is paragraph, I think it's paragraph 46. It should be on page, your Lordships are in the key documents bundle. It's also on page 46 as it happens.
Right.
Page 46, paragraph 46.
Thank you.
The natural and ordinary meaning, they say, is tolerably clear. It engages with the notion of the transfer of money or equivalent in satisfaction of a bill with the knowledge and consent of the payer.
Sorry, I'm in the electronic bundle.
Sorry, my Lord, if
page 46.
your Lordship's in the core bundle, electronic bundle, it's page 91.
91, thank you.
It's 46 in the key documents bundle, 91 in the core bundle.
Yes, I've got it.
So that is the respondents' parsing of what they say the word payment means. Now, we say, first of all, that in and of itself is not really an adequate definition. It starts with the concept of engaging with the notion of, whatever that means. But presumably it's meant to say involves the transfer of money or its equivalent in satisfaction of a bill. Well, we would agree on that. With the knowledge and consent of the payer. Well, what is meant in that context by the knowledge and consent? As I understand it, the respondent's case and the Court of Appeal's decision is to the effect that knowledge and consent comes from what we've already referred to, which is the prior agreement saying you can use monies received to pay our costs. And so what it divorces from the definition is any concept of consent to the use of monies to pay the specified sum demanded in the bill. And so, returning to the question the Lord Briggs asked, the focus of the gap between the parties here very much is focused on that question of, is the client, in order for there to be payment, does there have to be consent by the client to the sums demanded, the specified sum demanded, rather than a general authority saying, you can use my monies to pay your costs. That really is the focus of the gap between the two, and it may not be a very wide gap, but it's an important gap.
Yes, and I think it would certainly help us if you certainly develop any submissions you want to make about what the purpose of this provision is.
Lord, yes, I will do exactly that, and I'll come to that, if I may, in just a moment. We do say that when we're going to come to this, your Lordship already has my core point as to what we say are. Your Lordships have my core point as to what we say the appropriate definition is. We do say, and we'll come very shortly to the Act itself and looking at its purpose, we do say when we look at that, it is important to recognise that we say this process is in essence a reactive process. So the concept of payment in its context involves a reactive process to the demand made in the bill. And that is, we say, an important point. My Lord, just before I come to turn to the Act, which I will do relatively shortly, your Lordships will have noted that there has been something of a change of the respondent's position in relation to this appeal from the way the issues were addressed below. The hearings below very much proceeded in relation to arguments as to what the effect of existing authorities dating back to the 1843 Act had on the construction of the term payment. The issue that's primarily now raised against us in this court is whether or not we are able, or whether this court is able or should, look at those earlier authorities and the prior incarnations of this Act as an aid to construction of this term, because the 1974 Act is a consolidating statute. I'll come to that point specifically in a few moments as to why we say it will be of assistance and this court is entitled to look at the prior authorities insofar as this court thinks that they assist. But we do highlight just at this stage for the court's benefit that if the respondent is wrong in relation to that, so in other words, if the respondent is wrong in saying that the court should not look at those authorities, its case in relation to the effect of those prior authorities is very light indeed. It doesn't really engage with the fact that we say those authorities strongly support the proposition that I have been advancing. Rather, it focuses on two narrow points which I will develop. The first is that they say the first of those authorities, a case we will come to called Re Bignold, is of no assistance because it refers to what was the predecessor of the modern incarnation, which is Section 71 of the Act, which is to do with third-party rights to assessment, not Section 70, which we are dealing with. And so their case is that authority can be disregarded because it's the wrong section. We say shortly that's a bad point for the very obvious point that if you've got the term payment in two sections, one of which follows the other, which serve essentially the same purpose, you would expect it to have the same construction in both sections. The second part of their case in relation to the antecedents is that the subsequent cases, and in particular a case called Re Ingle, is decided per incuriam, that's how they put it in their written case of paragraph 75, for the very reason that the court dealing with that case didn't appreciate the point that Re Bignold was talking about Section 71 and not Section 70. We say, and again I'll develop this to the extent necessary, that that is simply wrong, essentially for the reason we've given in relation to Re Bignold. But also because in Re Ingle, insofar as Re Bignold had set the principle in respect of a different statutory provision, that provision and its interpretation was adopted in relation to the equivalent to Section 70 in Re Ingle and the subsequent cases. So we will deal with that point, my Lord, but once we deal with it, we say, in fact, there is very little, if anything, left in the respondent's case to contend, as they contended before the Court of Appeal below, that the antecedent authorities do not support our position, and we say when we come to look at them, they do.
Well, I assume they're adopting what the Court of Appeal said about the authorities.
Well, Lord, one might assume that, although it's not a point that they advance with any force in their written case, one might think.
Well, we'll have to consider what the Court of Appeal said about them anyway.
Of course, and I will of course come to that.
We did ask the registry to just draw to your attention that in yesterday's hand down of the judgment in Manchester Ship Canal number 2, there is a bang-up-to-date statement of principle about how you construe consolidating statutes. I'm not suggesting it changes the law at all, but it's the most recent.
My Lord, yes, and we're very grateful to your Lordships and to the Registrar for sending that to us, and I'll come to that, if I may, insofar as...
I mean, you can do what you like with it, but we just thought you ought to know about it.
Well, certainly I'll treat it very politely, if nothing else, but yes, my Lord, we'll come to it shortly. So our case, in response to the respondent's case on this point, in terms of the Consolidating Act point, can be, or the respondent's case generally, can be summarised, we say, in 3 short points. The first, and this is the point I'll come to when we turn up the Act in just a few minutes, the first is that we say that when we look at the word of payment in context of Section 70, and Section 71. We say it supports the definition that I've already identified for the court, that it involves the transfer of monies in the amount of a received bill, so the specific sum of a received bill with the client's agreement. Our second point is that we say in any event, insofar as there are already authorities, none of which of course bind this court because none are at the level of this court, but insofar as there are already authorities at the Court of Appeal level in relation to the 1974 Act, and we will come particularly to a case called Goff and Chivers, we say that they are consistent with and support the meaning that we advance and are contrary to the respondent's meaning. And Goff and Chivers, returning to the point the Lord Legate raised a moment ago, will be of some particular relevance because it's the case that the Court of Appeal specifically cited a dictum from with approval as identifying the definition of what payment meant. And we say, bluntly, that the Court of Appeal has misunderstood the facts of Goff and Chivers, and when we come to look at it, it will be clear that, in fact, Goff and Chivers supports our construction and not the construction adopted by the Court of Appeal and advanced by the respondents. If we're wrong about all of that, we also say that in any event, the respondent's case overstates the position in relation to construction of a consolidating act, and that not only do the antecedents and case law identify that there has been a long-established position until the Court of Appeal's decision in this case as to what payment meant, which is consistent with our case. But insofar as this court is left with any real doubt or uncertainty, having looked at the Act and the authorities on the 1974 Act, then it is likely to be of real assistance to this court to look at what those antecedents provide for. So, my Lord, against that background and that sort of run-up, during the course of the next hour or so, and subject to any contrary direction to the court, I firstly intend to look at the approach to construction of consolidating statutes. Then I will come to the statutes and what we say is their purpose and the construction of the term within that context. And then to the authorities on the 1974 Act, then to the extent it will assist to the earlier authorities. And then to the question of where we say the Court of Appeal went wrong, to the extent it's not clear by that point. So, my Lord, can I deal firstly with the question of construction of a consolidating statute, where I'm only too well aware that this court knows only too well how to approach the question of construction of a consolidating statute. My learned friends rely on the decision of the House of Lords in the case of Farrell, and if I could just invite your lordships to turn that up very briefly. It's at page 371, starts at page 371 of the core bundle.
I'm using the electronic bundle.
It is that number, yeah.
Pagination. I hope, Lord.
Yes, it is. That's fine.
Unless something's gone badly wrong, it should, I hope.
No, that's fine. Thank you. Farrell and Alexander.
So Farrell and Alexander, decision of the House of Lords, 1976. My Lord, I'm not going to delay on its facts. It was concerned the terms in the Rent Act, and in particular what the meaning was of the simple term any person in Section 85 of the Rent Act. The relevant part on which my learned friends rely is page 384, the speech of Lord Wilberforce. And there are two propositions which we don't dissent from, but we say it's relevant to see them and then to consider them in light of what this court has said subsequently. The first is at the bottom of 384, letter H, the sentence beginning, I would agree and endorse the principle. And then, my lords, if we come over the page to page 385, we can skip the next sentence at A, following on from that, and then, in fact, pick it up partway through that sentence, and then we come to but unless the process of consolidation, just below, above letter B. If your lordships will be kind enough to read that down to letter C, where it ends with substantial difficulty or ambiguity, which classical methods of construction cannot resolve. The Lords, it's an issue that this court has turned to on a number of occasions, including in Potter and Canada Square operations last year, a case relied on by my learned friends, but not in the bundle because the principles are not in dispute. And of course, as your Lordship has, Lord Briggs has helpfully pointed out, very, very recently in the Manchester Ship Canal Company case. Do your Lordships have a copy of that case available? We have hard copies if it was it was rather too late to make it.
We can easily get it on screen.
My Lord, we have hard copies if it would assist. Lordships.
You want it?
For me, yes, please.
Yes, please.
Okay.
That's fine, I'll take those.
Lord, we'll hand up a number of copies for those it will assist and for others who haven't. So this is the judgment handed down just yesterday by this court, seven-member panel of this court, construing terms in the Water Industry Act 1991 and their effect on common law actions in nuisance. My Lord, again, the facts don't need to trouble us, but if we can just come to a number of short extracts in the judgment of Lord Reid and Lord Hodge, with whom the other members agreed. If I can pick it up at paragraph 53. Apologies, we don't have an electronic pagination, although for those using a PDF, it's page 26 in the PDF.
Yeah.
So, my Lord, at paragraph 53, their Lordships, if we can pass over the first sentence dealing with the long title of the Act and then pick it up at the second sentence, where their Lordships deal with the significance of the fact that the Act is a consolidation statute. And I'd invite your Lordships to read down until we get to the extract from Crays on legislation, which I don't think we need. And then if your Lordships will be kind enough to come on to paragraph 110, which is page 44, I think, in the hard copy, page 45 in the PDF version.
Yeah.
And again, we can skip over the first sentence, but if your Lordships would be kind enough to read from the second sentence beginning, although the 1991 Act, through to the end of that paragraph.
this court, in that case, spent a great deal of time on the prior legislation.
It did indeed. It spent a great deal of time in the prior, on the antecedents, as they're sometimes referred to. Your Lordship will have noted the reference to, of course, the Manchester Ship Canal case had been before this court previously, and there's reference in that paragraph to a dictum of Lord Sumption in the first of the Manchester Ship Canal cases. There isn't a copy of that available, but as I understand it, and we can provide it if it will assist, Lord Sumption at the paragraph 3 referred to described the principles in relation to construction of consolidating acts as not so much a rule of construction, but as a valuable warning against the over-ready assumption that a consolidating act means the same as prior enactments. So it's a klaxon, a warning bell, to say don't assume these things, don't go there too readily, but we say, to summarise if I may, we say it is a tool there to be used if the court considers it will be of assistance to it. But the court shouldn't be overly ready to go there.
I mean, that is really what Lord Simon says in Farrell and Alexander at page 402 of the bundle, when he's discussing the Barras doctrine and its impact on consolidating statutes. And effectively, he's saying if you've got authorities of high standing or have been long accepted, then that is background against which the drafter of the consolidating statute will have drafted the way he or she has.
My Lord, yes, although, again, this court and the House of Lords have been careful to say that the court shouldn't be over ready to presume that that is the case.
No.
And
I mean, he says, on this approach, the previous judicial interpretation is merely one of the facts within the knowledge of the draftsman in the light of which he will draft.
My Lord, yes.
It carries to his knowledge as much authority as it bears under the general doctrine of precedent, but no more.
My Lord, yes. And we wouldn't put it any higher than that. We do not say, for example, that reference to prior enactments should be the first recourse. We also acknowledge the caution that the court should exercise. So the court should not assume, for example, that the prior enactment was carried forward in the same form, and therefore that what has been said in relation to the prior enactment can be taken to have equal force to the present enactment. We would acknowledge that. But where there is an ambiguity, where there is an uncertainty, where you have, as we say we have here, an enactment which, whilst it has undergone some structural change to present it in a more comprehensible and easy to follow fashion, brings forward, we say quite transparently, the same substantive provision, and that substantive provision has been the subject of considerable authoritative consideration, then we say this court may find consideration of what those courts have said about it of use. We also say that the respondent's approach of suggesting that, in effect, whatever has been said about the prior enactment should be essentially thrown out or not regarded, because in some way the court should assume that by virtue of consolidation there's some form of substantive updating of the Act. It is itself a flawed proposition. That's not correct. Of course, the nature of consolidating acts is that they are intended to consolidate, not to change. That's their usual purpose, unless there is a clear indication that something else is going on. That's why they're consolidating acts, if I can put it that way.
Yes, it's a slightly odd situation in which we're bidden to understand that the law may remain the same as a result of a consolidation, even though the language has been modernised.
Indeed so.
But here the suggestion is that the law has actually quite fundamentally changed, even though the language is exactly the same.
Yes, and we say that can't be right. And indeed, we say it would be contrary to what this court has said just yesterday, that I took your lordships to at paragraph 53 of the speech of the judgments in the Manchester Ship Canal, which is that consolidating statutes are not intended to make substantive changes to the law, but to present the existing law in a newly organised structure and language that is modern and certainly consistent. And we said that's exactly what's been going on with the 1843 Act, through the 1932 Act, through the 1957 Act, through to the 1974 Act. So that is, we say that's the process. And if this court is satisfied that that is the process, then we say it is likely to find, and of course this court can tell me I'm wrong, it can tell me that it doesn't find any assistance from the cases, but we say it's likely to find assistance from those cases as to what that meaning is of that term which has been there all the way through, which has served the same purpose all the way through, and which has been carried forward.
I'm not sure, I may be wrong. In Manchester Ship Canal, it was really a focus on earlier authorities construing the provisions of the earlier statutes.
Lord, that's my... I can't...
I think that... No, I mean, the point was that the earlier statutes had not excluded common law claims,
yes.
And nor did the relevant Water Act.
1991 Act, yes. Exactly. That's my understanding, Lord. But
I mean, this case raises a point about the extent to which the court, in construing a consolidating statute, should have regard to prior judicial decisions on the earlier statutes.
Lord, yes. So, Lord, I don't intend to develop the point in relation to the Consolidating Act and whether your lordships can have regard to the prior authorities any further than that. We say it is open to your lordships to do so. There is no restriction on your lordships doing so. Whether when we come to them your lordships consider that they assist is of course a secondary point. Just on that point, Lord, and this will then segue into looking at the acts themselves and our points on the purpose of the act and the construction of the terms in context. As your lordships will be aware, part of the respondent's case is to say that it is important that the Act be construed in its modern context. Now, whilst we accept the point that essentially an Act is to be regarded as always speaking, we do say, and Miss McGungle will develop some parts of this in due course, we do say that there is nothing in the respondent's complaint that our construction of the term payment is in any way deleterious to the modern practice of solicitors. And we essentially say that for four reasons. The first is that we say the particular provisions we are going to look at are primarily consumer protection provisions, or client protection provisions, I should say, because not all clients of solicitors will be consumers within the term as it's defined in certain other provisions. So they're client protection provisions aimed at giving clients greater protection than they would ordinarily have at, for example, common or contract law. That focus on client protection is something which, if anything, has grown over the years since the 1843 Act. But even in the 1843 Act, and your lordships may have seen that we've included an extract from Lord Langdale in Hansard in 1843 in our written case, which we'll come to in due course. But we say even in 1843 it was clear that the introduction of these provisions was a client protection provision. And that's an aim and purpose which has only grown in importance since the 1843 Act. So it would be peculiar, and we say this is one of the flaws in the Court of Appeal's approach, it would be peculiar if we end up with a 2024, or in the Court of Appeal's case, 2022 construction of a provision which ends up with less consumer protection than the equivalent provision in earlier acts was interpreted by earlier courts as providing. Lord, our second point in relation to that is that we say the protestations as to the difficulties for modern solicitors' practices are in any event hollow. We will see, and we will come to a particular case where your lordships can see how the Act operated in practice in the 19th century in terms of what solicitors were expected to do by way of obtaining their client's agreement to a specific bill. But we would say, if anything, in the modern world of emails, texts, WhatsApp, and whatever else we may have by way of modern communication, it is in fact far easier for solicitors to provide documents to their clients, to seek their client's agreement to them, and matters of that kind, rather than, for example, having to get the client in the office or difficulties of that kind.
Do solicitors now use WhatsApp?
My Lord, I believe they do.
I'm not saying that critically.
It's not something I can speak to particularly myself, but I understand that it does happen. But modern communication is a remarkable thing when it works well, and it provides far greater tools and resources to solicitors to allow them to provide information to their clients and to seek their approval in a form which is efficient and far less time-consuming than it was in the days of the cases that we will come to look at. Lord, our third point in relation to why the protestations are hollow is that we say that there always has been built into the very provision that we will look at a protection for solicitors where, if we're right in our construction and they need to obtain the client's approval to the sum in a specified bill, if the clients drag their heels and fail to respond, the solicitors are able to obtain court approval of their bill through Section 72 of the Solicitors Act 1974, and therefore to deal with any delay or lack of engagement by the clients and obtain the certainty that they seek in terms of being able to retain or take payment of the monies that they wish. And that will be developed by Mr. McGungle in due course. And the final point we make is that we say, and if we are correct, that the interpretation that we advance is consistent with the interpretation that's been advanced for the last 180 years. And to put it even more bluntly, the interpretation that if a client asked a solicitor to look up how this Act worked 2 years ago and they looked up the notes in the White Book as to the Solicitors Act 1974 and they would have been told an interpretation consistent with our interpretation, if that's how it stood for the best part of 180 years, then we say it's surprising that these problems that my learned friends say will be the consequence of our construction have not caused the problems that they say they're going to cause already, because we do say we are not the ones upsetting the apple cart here. We say our construction is the construction that has essentially operated. What's upset the apple cart, what's led to the sea change, what means that if you look at the 2024 White Book and look at the notes in it, it's now different to what it was up until 2022, is the Court of Appeal's decision. And just on that, my lords, a very general point, if I may, before turning directly to the Acts. Your lordships will have seen that my learned friends rely on certain dicta from the Master of the Rolls, both in this case and in an earlier case on the Solicitors Act called Elsner and Cam Legal Services, where the Master of the Rolls rails quite forcefully against some of the inadequacies of the Solicitors Act and as to whether it is suitable for modern consumer protection and modern solicitors' practices. And I would be the first, if I could be bold enough, to agree with him on that. It is an act which requires, in my humble opinion for what it's worth, which requires proper legislative review and reconsideration by Parliament. But that, of course, is not to the point here. We don't say there's any need to rewrite the Act to the solicitor's benefit at this stage, but if what is required is a wholesale reconsideration of this Act, then whichever form of government we have in place following tomorrow, that's a matter that they can pick up should they choose to do so. So, my Lord, can I then turn to the statutes? Lord, I'm not keen to indulge in your Lordships in a very detailed reconsideration of all of the history of the Solicitors Act, and I'm going to avoid doing so unless I'm directed by your Lordships to do so. I will simply note for your Lordship's benefit, if I can be lazy in doing this, that Lord Justice Nichols, in one of the cases in your bundle, in a case called Harrison and Chew, gives quite a detailed exposition as to the background to the Solicitors Act, right back to the early 18th century, and that starts at page 448 onwards in your core bundle. I'm not going to invite you to...
448.
448, my Lord. But even insofar in giving your judgments, it would be of assistance to see a further, more detailed history of the background of the Acts. Then it can be found there, if I can be forgiven for relying on Lord Justice Nichols' work rather than my own. But I'm going to pick it up, if I may, with the 1843 Act, because that is the Act that introduces the provision that then becomes the provision that we are dealing with. And the 1843 Act starts at page 259 of your core bundle. And as your Lordships will see, that was itself a consolidating act, amending several of the laws relating to attorneys and solicitors, although, as I say, it was the introduction of the provisions that we are going to consider through there.
Well, it was a consolidating and amending act.
Consolidating and amending act, Lord, yes. But for our purposes, it's the genesis of the provisions that we are considering. And if we can come on to page 273, we can then see those provisions. And so what I intend to do, my Lords, I'm going to take your Lordships very briefly through these provisions, and I'll indicate as I do with each one where we can find its modern equivalent in the Act that we're going to come to. So under section 37 on page 273, we can pass over the first paragraph, which is a clause which essentially says solicitors shan't issue proceedings to recover their costs until a month has passed since a bill has been delivered. But for our purposes, if we can pick it up at the second paragraph, starting reference of bills, whether relating to business transacted in court or not, for taxation, which, as your Lordships will know, was the expression used until relatively recently for assessment of costs. So this whole paragraph here, down to where it ends with the words such reference, this is the 1843 equivalent of what we will see is section 70 subsection 1 of the 1974 Act. I'm not going to go through it all, but we can see from the second sentence that this part relates to an application by the party chargeable with the bill. And just pausing there, your Lordships will note as we go through that when it comes to the equivalent of section 70 subsection 1, which is an application for an assessment within a month of delivery of a bill, that is a right that's only given to the party chargeable with the bill. So that's only given to the client. So on an application chargeable by the party chargeable with the bill within 1 month, we can follow it through. We don't need to follow through about all of the different courts, but it will be lawful. And then if we pick it up about 7 lines from the end, partway through that sentence, it says, to refer such bill, ... thereupon to be taxed and settled by the proper officer of the court in which such. And reference shall be made without any money being brought into court. So as your Lordships will see in a moment, that's the equivalent of the modern section 70 subsection 1, which says if a bill is delivered, the the party chargeable, makes an application within 1 month, they can have an assessment and no money has to be brought into court, so no conditions can be imposed on it. The court can't impose a condition that you have to pay in order to have your assessment. So within 1 month, you have an absolute right to an assessment. There are then qualifications placed on that, and so we then come to the next heading, which is taxation after 1 month. So this section, down to the end of the page, is the equivalent of what is the modern Section 70, subsection 2. And so it starts on the basis, obviously on the premise that no application has been made within a month, under the previous section. Then it shall be lawful for the reference to be made as aforesaid, and here we come upon the first material change, either upon the application of the attorney or solicitor. So this is where the solicitor is given the right, if the client's not done anything within a month, to seek their own assessment of their own bills so that it can be determined and they know that that money is theirs to keep, ... or upon the application of the party chargeable, with such directions and subject to such conditions as the court or judge shall think proper. So if you're outside the month, either party can apply and the court can impose conditions. And then if we come over the page to 274, we then come to taxation after 12 months under special circumstances, and that's the term of art, the specific term that continues through to the modern incarnation. So this section here now is part of what is now Section 70, subsection 3. So again, it starts on the provision that no reference has been made under the previous subsections, and provided also there's not been a verdict, so there's not been a judgment, as the term is used in the modern equivalent. And then we come 4 lines down, or after the expiration of 12 months after such bill shall have been delivered, sent or left, except under special circumstances. So you wait past the 12 months, you have to persuade the court there are particular features of your case which justify an assessment. You've lost the free right. In this incarnation of the Act, Lords, the further qualification in relation to payment was actually in a different section. So we have to come on to page 276 to see that. At the very bottom of 276, we have taxation of bill after payment. Section 41. This is the equivalent of the modern remainder of Section 70, subsection 3, and what is Section 70, subsection 4. So payment of any such bill shall not preclude referring the bill for taxation if special circumstances appear to require the same. So once the bill is paid, and once you're out of the absolute right within 12 months, you only have an assessment if you can show special circumstances. So this comes back to the point we considered earlier on today with the Lord Legate. And then if we come to the last sentence...
The punch is in the bit at the end, provided...
Lord, yes, the guillotine is the bit at the end.
It's a somewhat oblique way of doing it, but I think the more...
It is, and what we'll see with the consolidated statute is it's rejigged to try and present it in a more comprehensive...
There's things in the tail.
Yes.
Yeah.
So that's
the same scheme.
It's the same scheme, using the same core terms, but just presented in frankly, a more opaque fashion. So the application must be made within 12 months. And then finally in this Act, my Lord, if I can invite your attention to the previous page, page 275. So immediately following on from the first section we looked at, which was 37, you have section 38 in the middle of the page. This is the equivalent of what is now section 71 of the Act. So this still follows on from what was the equivalent of section 70, and this is where the bill is taxed by third parties, or rather there's an application by third parties to tax the bill. So what is meant by a third party here is what we see in the second sentence. Any person, not the party charged, sorry, second line, not the party chargeable with the bill, but who is shall be liable to pay or shall have paid. So somebody else who's liable to pay, for example, they may have given some sort of guarantee, or may have agreed directly with the solicitors to be liable to pay, or they have in fact paid. They have a statutory right as well to challenge the bill. And then if we come up to 3 lines from the bottom in that paragraph, it refers to the bill as the party chargeable therewith might himself make. So he can make the same application that the party chargeable could have made for an assessment, and then it goes on saying the same reference and order shall be made thereupon.
So they can take into account special circumstances both of the party chargeable and their own.
Yes.
Yes.
So the court can take. It should be said, thankfully we don't need to trouble ourselves with it here. That section and its modern equivalent has caused a huge amount of difficulty. Has caused a huge amount of difficulty as to what it means, what circumstances third parties can, and what is meant by the same order shall be made in the same respects. And all of that has caused a lot of difficulty, which has been in front of the Court of Appeal a number of times, but thankfully none of which is material to our issues today, and none of which needs to trouble your lordships, at least until it gets to this level, as it may well do one day. But the important point for present purposes is that there is a third-party right, which again is determined by reference to payment, in part. Just in passing, your lordships will also note at the bottom of that page, there's a specific third-party right in relation to beneficiaries, in essence, of trusts or estates.
So would a third party who has paid the bill be subject to the proviso at the end of section 41? That would seem to follow from the words to make such application for a reference for the taxation and settlement of such bill as the party chargeable therewith might himself make.
But Lord, that is to some extent still an argued issue, but we will see one of the cases I will take your lordships to turns on that very point.
I see. Right.
And indeed, it's the very case where I say the Court of Appeal misunderstood the case. It's the case of Gotham Chivers, and we'll come to that shortly. Right. But in short, in that case, what happened was that there had been payment. This was an executor, an estate case. There had been payment by the executor with approval, and the question was whether you also required the specific approval of the beneficiary in order for that to constitute payment. And in that case, it was held that the payment with approval by the executor was sufficient, so the fact that the beneficiary hadn't approved was not a means to avoid the guillotine coming down.
It just says after payment, so it presumably applies to payment by anybody within the foregoing range of potential payers.
Indeed, my lord, or in particular, as we're seeing Gotham Chivers, the key issue was, as I say, where the party chargeable has paid, does the fact that the third party, who may have an interest, so that's the sort of beneficiary type case, does the fact that they haven't approved the specified payment, is there a second level, in essence, of qualification required to payment? And the Court of Appeal concluded there wasn't. But we'll come to that very, very shortly.
Thank you.
Lords, your lordships also have the 1932 Act. I'm going to pass over it very quickly. It starts at page 293 in your lordships bundle. Just to introduce it so your lordships have it, your lordships will see at page 293, this is a Consolidation Act, not a Consolidation and Amendment Act. And it replaced the entire 1843 Act. There's a schedule to this Act which sets out which acts it repeals and replaces, and that's at page 330. I don't invite you to turn it up, but it makes that clear. The equivalent provisions start on page 320. And on this occasion, I'm not going to go through the wording, but I'll just indicate so your lordships are able to follow it through, what's gone where and how it's all moved on over time. So if we can start at section 66. So this is essentially the equivalent of what was section 37, what is under the modern Act, section 70. Taxation of bills on the application of the party chargeable. Your lordships can see essentially the same provisions, but structured in a different way to try and make them a little clearer. So we start with subparagraph 1, which is the position within 1 month. So that's section 70, subsection 1 in the Modern Act. So the same effect. So within 1 month you have an absolute right, but no conditions. Subsection 2, which is in the modern equivalent is section 70, subsection 2. So if you're outside the month, then again we have the introduction of the solicitor's ability to make the application, just as in section 37, or the party chargeable, and the court's ability to impose terms, as we've seen. So the same effective provision, but just reworded. And then what we see over the page, on page 321, is section 41. So that section under the 1843 Act that dealt with payment, which was separate, has now been brought in to lump it all together, to bring it all together in a single section. So that the qualifications that were in section 37 about mere passage of time are still there. Little 1, if 12 months have expired. But then we see the introduction of or if the bill has been paid. So those are the provisions that were in section 41 are now brought into here. And then, the Lords, we have at little 2, the guillotine. Set out perhaps a little more clearly, but essentially the same provision. No order shall be made after the expiration of 12 months from payment of the bill. And then just to complete the little legislative trip, at the bottom of that page, 321, your lordships then have the equivalent of the previous provisions, section 38, in terms of taxation on the applications of third parties. Again, restructured, but to exactly the same effect. This is the old section 39, but in the Modern Act is section 71. Lords, nobody has put in your bundle, because nobody thought it necessary to trouble you with, the Solicitors Act of 1957, which consolidated all of the various Solicitors Acts from 1932 to 1956, because there was no, for our purposes, material change in terms that anybody considers it will assist your lordships with. And then we get...
So no change either in the language or the structure?
No change in the language or the structure. That's material to Lord, there are obviously some changes, but nothing that's material to these sections that we're dealing with. And then we come to the 1974 Act, which is as modern as we have managed to get so far. And your lordships have the relevant sections of that at page 338 of your core bundle. We haven't given you, your lordships, the front piece or indeed the earlier sections, but this was an act which repealed and replaced wholesale the 1957 Act and was a consolidating act, at least in relation to these sections that we are dealing with. And what your lordships will see at 338 is some harmonisation of the layout, but the same content, we say, the same substantive content. So if we pick it up at section 70, page 338, we now have, in fact this was a much more recent introduction, but we now have the term assessment, which was introduced by the Legal Services Act in 2007 to modernise the terminology. But that apart, we have the same structure. So subsection 1 is the 1 month, within 1 month, absolute right. No sum can be ordered to be paid into court. No action can be commenced. Subsection 2, applications outside the 1 month, the court can order assessment with conditions. And then subsection 3, which, as we've seen from the 1957 Act onwards, was a combination of what had been Section 37 and Section 41 of the 1843 Act. The same structure. So where you're after 12 months over the page, or there's been a judgment, or the bill has been paid, but you're within 12 months of payment, special circumstances are required. And then the guillotine, now broken out into its own separate subsection, but the same effect. The power to order assessment conferred by subsection 2 shall not be exercisable on an application by the party chargeable after the expiration of 12 months from payment.
The scheme of the Act seems to envisage, doesn't it, that there may be a situation in which you could, if you showed special circumstances, apply for an assessment after 12 months from delivery of the bill.
Provided the bill has not been paid.
Yes, but that there can be that situation.
There can indeed be that situation.
Whereas if the respondents are right, then whenever the solicitor's agreement is properly drafted, as it were, so that they can deduct payment, there will never be such a situation.
My Lord, yes. If all solicitors provided that we can deduct monies in this way, and that was taken to be sufficient, subject only to the delivery of a bill completing the process of payment, then yes, in practical terms, if that was the standard provision in all solicitors' acts, in all solicitors' retainers, there would never be.
If the solicitors efficiently made the deduction immediately after delivering the bill.
Provided the solicitor makes the deduction. Indeed,
if they delayed in making the deduction, then you might get back into special circumstances.
My Lord, we might, but in practical terms, my Lord Legate is correct. If all solicitors were to take from this case that what we should do is have words similar to Oakwood Solicitors in our retainer, and what we should do is then make sure we deduct the monies and then send the client a bill promptly. We don't need anything else from the client, and in practical terms, that would mean that there would never be an ability to have an assessment more than 12 months after delivery of the bill. It would simply not be possible because there would always be payment. And therefore the guillotine would come down. Now, of course, that may be a reflection of modern practice and simply, well, this is essentially a Victorian statute. Modern practice has developed to the effect that it is possible for solicitors effectively to render Section 70 subsection 3, Section 70 subsection 3A of no real purpose. It may be that that's just a reflection of modern practice condemning part of an old act to the scrap heap. But we say that would be a surprising conclusion. Well, I'm grateful to your Lordship's bearing with me for that trawl through relatively quick.
Just before we leave,
Of course, Lord.
I think you said earlier that one of the criticisms of the old cases was that it was based upon the use of payment in a different section.
Yes.
You haven't, I think, taken us to where that other use of payment occurs.
My Lord, the other section, and I'll take you to it immediately, but it's
by all means, do it later on, but I'm just, since we're going through the Act, it would be quite helpful to see where.
My Lord, of course, it's section 71, so your Lordships have it over the page on page 340. And we've seen its predecessor in various forms. So this is the third-party charge.
Oh, the third-party one, yes.
And my learned friend's argument is that the case of Reed Bignold was a case which related to section 71. So when, and it's the point that was raised a few months ago by Lord Richards, where the issue is raised under a Section 71 third-party application of the question of whether you can make the same order as you could have made if the application had been made by the party chargeable, and you couldn't have made an order on the application by the party chargeable because the bill had been paid, then does the same guillotine come down under Section 71? And so my learned friend's argument, as I understand it, in relation to Re Bignold, is the court was considering Section 71 and the effective payment on Section 71, and therefore we can't take from Re Bignold's consideration of the effective payment anything in relation to Section 70. And we say that that's wholly wrong, because it's all predicated on what's required under Section 70 in any event. It all flows from Section 70. So that can't be right. But Section 71, just for your Lordship's benefit, is the modern equivalent of the provision in relation to the application of third parties. And your Lordships will see, and I don't want to take any time up on it unduly, you've got the Section 71(1) position, which deals with essentially the position of a party who has paid or is liable to pay a bill. And you've got the Section 71(3) provision, which deals with trustees and executors who've been liable to pay bills and the abilities of essentially the beneficiaries to seek assessments. I don't want to complicate matters, but those two sections are essentially, for practical purposes, different sections. So the rights for a beneficiary to challenge bills paid by a trustee to their solicitors are different to the rights just generally for an ordinary third party who simply paid their friend's bill or whatever it might be. And that's, in fact, there's a case in your Lordship's bundle called Kennig which deals with that, which I won't take you to, but that was the Court of Appeal's decision on those points. So, my Lord, can I just come to what we say in relation to all of this? In terms of what we say in context is the effect of payment. And payment is, for our purposes, is that word used in Section 70, subsection 4, on page 339, but also, of course, used, it's not payment, it's paid, and then payment in Section 70, subsection 3C, just above that, after the bill has been paid, but before the expiration of 12 months from payment. So those are the references to the term in this particular section. Our summary in relation to this is, we say, first of all, that the overarching purpose of these sections, Section 70 and Section 71, is to provide clients with specific statutory rights to challenge bills. I don't think there can be any dispute in relation to that, but if there is, I'll deal with it in reply. So the clients don't need to bring claims for breach of contract or to require the solicitors to sue them for a debt which they can respond to by a defence that the costs are unreasonable. They have a freestanding statutory right to ask the court to assess the reasonableness of their solicitor's bill without any need to assert wrongdoing by the solicitors. And we do say that the focus of this section is all in relation to a specific bill. So it's all dealing with the delivery of a bill, whether that bill is capable of assessment, whether that particular bill has been paid. And it will be an obvious point to your Lordships, but it's an entirely common argument in relation to Solicitors Act assessment cases, that the client can have an assessment of some bills, because some bills are, for example, still within a month when the application is made, but others are older. Entirely common, particularly in modern practice, that on-account bills are delivered. Some bills are older than others. The rights apply to some bills and not others, and they are decided on a bill-by-bill basis, unless there's only one bill, of course. So this is bill-specific question of a client's right to assessment of their bills. However, those enacting these provisions have seen it fair to ensure that those challenges, those rights to challenge, are not open-ended. It's not simply a client can challenge whenever they want, for as long as they want, no matter what, any bill rendered by their solicitors. And the reasons for that are, of course, obvious and don't need further explanation. And so certain limitations are placed on those rights. And the first, as we have seen, is the mere passage of time. If you leave things too long, your right to have your bill assessed becomes restricted. It doesn't vanish, but perhaps entirely understandably, the broad rubric says you have to show special circumstances if you let it pass for more than 12 months. In other words, you've got to explain to the court why, all this time having passed, you should still be entitled to take up the court's time. Perfectly understandable. The second major restriction is that if the bill has been paid, and that has two effects, as we've seen. Firstly, it brings forward that additional hurdle, the special circumstances, so that 1 month after payment of the bill, you now face that additional hurdle. And secondly, if you sit on the bill for more than 12 months after you've paid it, you lose that right. And that's clear. Those restrictions are not in any doubt. Their precise operation is. The question we invite the court, if I can be bold enough to ask a rhetorical question, is why? What is it in this context about a payment of the bill that means those additional restrictions should be imposed? And our submission is that that is because, we say the proper inference to draw from it is because payment of the bill in this context stands as a proxy for agreement or approval of the bill. The reason payment is taken to justify the introduction of these restrictions is because payment is taken to reflect the client accepting the demand the solicitor has made to them in relation to that specific bill.
The structure of the Act seems to envisage that payment will necessarily follow delivery of the bill.
It does.
But on the Respondent's case, it seems to me that may not be so. I'm not quite clear exactly when they say the bill was paid in this case.
Well, my Lord, there's a slight qualification to the Respondent's case, which is that, as I understand it, even if payment was taken earlier, and payment may well be taken earlier, they can't achieve payment under the Act without completing that act of payment by delivery of a bill.
Yeah, but that's making the delivery of bill and payment one and the same thing. And the Act clearly envisages that they're not one and the same thing.
My Lord, yes.
Well, obviously, that's a point for me to put to your opponent, not for you.
I was going to say, I'm not going to try and answer his question. I'm sure Mr. Miles will do that more than himself. But yes, that is one of the oddities, that on their construction, and if we were to go down the hypothesis that the Lord advanced earlier, which is all solicitors take the approach of saying, well, we'll have a general provision which says whenever money's come in, we can use those to pay our costs. And all we need to do to complete that is then send you the bill. Then payment, in practical terms, will nearly always take place before the delivery of the bill. In a sort of common sense terms, they'll take the money, but then the payment is completed for statutory purposes by the delivery of the bill.
Where does that, which provision has that effect?
Lord, to permit them to take payment.
Well, I mean, I think on the facts of this case, the letter enclosing the final bill was sent on the same day as payment was made from the client account to the office account.
No, I think it had already been made, and that actually a payment was being made because there'd been an overpayment. So money was being paid back.
Well, I assume that the money was in the client account. There was, I think, funds were sent to the client, 22,000 or something, and the balance, I had assumed that was transferred at that point to the office account.
No, I don't think we know. I don't think we actually know when the final transfer was made. But what we do know, and I'm not inviting your Lordship to turn it up, but just for your Lordship's benefit, this is the witness statement of a Miss Bell at page 167 of your core bundle, is that on the 25th of March 2019, the solicitors transferred £25,000, so that was the first part of their payment, from client account to office account. And that was the 25th of March 2019, and that is nearly 4 months, it's 3.5 months before the statute bill on which the respondents rely for payment was delivered. The statute bill being the 11th of July 2019.
11th of July, yes.
11th of July 2019, which is page 159 of your Lordship's bundle.
So 25,000, I see.
So at least part of the payment had been taken. Now, I don't want your lordships to think that I'm throwing mud and saying something improper has been done here. I'm not. And again, I'm wary of going down oddities, but under the solicitor's financial service conduct of business rules, you're entitled to transfer money from client to office account, provided you have given the client some written notification that you are going to do so, even if you've not delivered a statute bill. So I don't say it was impermissible of them to transfer the money from client to office account. But it does raise interesting questions as to this point that it is entirely possible that solicitors will get money in from clients, for example, damages and costs they're receiving from another party. They will write a broad letter saying we're going to transfer, we don't know what our final bill is going to be, but we're going to transfer £50,000 from client to office account, which will allow them to do so. And then 6 months later, they deliver the bill, and the delivery of that bill, even if it's in a different sum, will have the effect of meaning that that transfer earlier stands, albeit with the date of the delivery of the bill, as payment under the Act, which we say is not what we say this Act is contemplating.
How do you say the statements of fact says there's a chronology?
Lord, there is. That would probably have been an easier place to take you, your lordships, to it. There is a chronology which is at the start of, I believe it's at the start of the appendix, which if your lordship will just give me a moment, is page 107. I'm very grateful to my learned friend.
Right.
I don't think that chronology is usually helpful, but you can see the fourth entry, transfer by the respondent of £25,000 to office account, and then 2 entries after that, the service of the final statute bill. So I just wanted to be clear, I'm not saying that constitutes anything improper.
No.
I think it's important that I make that clear in this context of this court, but it is an oddity.
But you say that that's not payment until the final statute bill was delivered.
The respondents in the Court of Appeal say that's not payment until the final statute bill was delivered under the terms of the Act.
What provision of the Act says that?
Well, my Lord, it's because there cannot be payment until a bill has been delivered, is the general understanding that's advanced before you.
Another inference could be drawn from it is the Act doesn't contemplate a possibility that the delivery of the bill could itself affect payment.
My Lord, yes. So my learned friend does not say that there has been payment. There was some argument about this below, but doesn't now say, and didn't say in the Court of Appeal, that there's been payment any time earlier than the delivery of the final statute bill. What they say is the prior authority to deduct monies, and then the deduction of monies whenever they happened, as long as it was prior to the statute bill, is then completed and transformed into payment by the delivery of the statute bill. The final step in that process is the provision of notice, which is the delivery of the statute bill.
Lord, finding it quite baffling, but never mind, it may come out in the wash.
In a sense, it's the respondents having to adopt a non-natural meaning of payment, because you think payment is when the funds move across, but in order to make it fit, they have to say, oh no, it's payment, and
it becomes payment when we deliver the bill, and the question is whether that's consistent with the scheme of the Act.
Well, we say it's not authority, but if I may, my lords, I'm not going to spend too long trying to answer my learned friend's case, because he will do that very well himself. My lord, can I then take you to, unless there's anything on the Act itself, we'll consider some of the terms of the Act when we look at how the cases have dealt with it. So we will be coming back to it. But unless there's anything else on the specific terms of the statute that's in front of you, may I take your lordships to the cases? And my lords, as I indicated in my opening, I intend to start with the cases insofar as they assist, or we say they assist, in relation to the 1974 Act, construction of the 1974 Act, before I jump in my time machine and head back into history.
Instinctively, one would perhaps want to do the time machine bit first, but I won't take you out of your...
But Lord, I'm very happy
if it matters to you.
It doesn't matter to me. I'm very happy to jump in the time machine first and then move my way forward through history. So I'm very happy to take it in that order. So, my Lord, in that case, if we can start going back in time to the earliest case, and I've teed it up and sort of promised it already, which is the case of Bignald. I mentioned it a couple of occasions because it's part of my learned friend's case that they seek to say that this case was wrongly relied on in re Ingle, which we'll come to, because it's to do with a third-party assessment. So, my Lord, that's page 490 of your Lordship's core bundle.
490?
490.
And that's the 1843 Act?
That's the 1843 Act. In fact, it's a very early case on the 1843 Act, 'cause it's an 1845 case.
Decided by the promoter of the bill.
Decided by the promoter of the bill, indeed.
Yeah.
The Master of the Rolls. So, the facts in relation to this case, they're set out. I won't delay unduly on them, but this was to do with the position, again, it's a third-party case, so mortgagees, solicitors. There was a bill sent in relation to a specific sum, so obviously a bill for a specific sum, and the monies in relation to that were retained from the proceeds of sale. And then there was a challenge by the mortgagor, who obviously is the person who ultimately ends up carrying the can for those monies under their mortgage, as to the amount of that bill. And the important point for consideration in this case was what payment meant, and in particular, whether the mortgagee could properly be regarded, because he was the party chargeable with the bill, properly be regarded as having paid the bill. So if we just pick it up, my Lords, if we can come, it's a very short judgment. Master of the Rolls, Lord Langdale, at the bottom of that page, identifies the question in this case, identifies that it's a third-party liability question. And then he goes on to note, there's a sentence beginning about 5 lines in that paragraph, a mortgagor has the right to have a taxation of the mortgagee solicitor's bill. So that's the third-party right, because he's liable to pay it. And then he goes on, but if the mortgagee thinks fit to settle with his solicitor and pay him, then although the right of the mortgagee to charge the full amount against the mortgagor is left quite open, the mortgagor cannot, as of course, open that settlement. So in other words, it's the mortgagee's payment, because of the provisions we've looked at, which relate to the ability to make an order for a third party being limited to the same order that could be made in relation to the party chargeable. It's the mortgagee's payment that inhibits the mortgagor's ability to challenge. And then if we come over the page, Lord Langdale identifies in the first full paragraph on that page, there is a difficulty in the present case. If there hasn't been a settlement, then the petitioner is entitled to obtain an order, of course, for the taxation of the bill. So if there's not been payment by the mortgagee, the mortgagor's right isn't fettered. And then, very shortly, 3 lines up from the bottom, here the case stands thus: there has been an account stated, but not settled. There has been nothing finally concluded, and the mortgagor comes for a special order for taxation. He is entitled to it. So the guillotine doesn't come down because the mortgagee is held not to have made payments for the purposes of the Act. And if we just come back then to page 490 to see what had happened in terms of the facts. The third paragraph under the facts, beginning in November 1984 at the top of the page, there had been a cash account. A bill of costs was delivered to the petitioner. The amount was debited in the cash account, and upon the cash account there appeared after such deduction to be a balance due. But what there was an absence of was any specific approval by the mortgagee to the sum. And if we come to the very first part of the Master of the Rolls decision, you say that the solicitor, as between himself and client, has retained the amount of his bill. I have never hitherto considered that the mere retainer by the solicitor out of monies in hand of the amount of his bill amounted to a payment unless there has been a settlement of account.
I don't think that's his decision, it's just an interjection in the argument.
I think it is. I think your Lordship is quite correct, but it is an interjection. But it's an interjection that's been relied on as an indication of the Master of the Rolls' understanding in the subsequent cases, that where you have a solicitor who takes monies out of proceeds which are in their hands, but doesn't obtain a settlement of account, in other words, doesn't obtain the clients, and here it's the client, the mortgagee, their agreement to a specific sum, that retention does not amount to payment. So that's not the high point of our case, but I take it to you because it's the sort of foundation stone that the subsequent cases step on, and it's the case that my learned friends say the subsequent cases were wrong to use as their foundation stone because it was a third-party case, and your lordships have my point as to why the fact is a
and
third-party
he's,
case.
I mean, his mindset is not construing a brand new act of which he happens to have been the promoter, but what the position has always been.
He takes that to have always been his understanding, indeed. Yeah. I don't go that far.
Both there and in the judgment itself.
Indeed so. I don't go that far, my lord, because I'm simply taking the statutory provision from what we can see as its statutory genesis.
Yes.
I've saved your lordships. Perhaps I've erred in not giving your lordships the benefit of a much longer history as to any common law.
Well, that takes us back into the 18th century, I think.
Yes.
I mean, it doesn't really address the present point because he's not considering whether there can be a pre-agreement, as it were.
Indeed so.
I mean, he is just saying, which must be obvious, that you can't simply pay yourself, as it were.
My lord, I absolutely. But
you've got to get the client's agreement for it to be payment. But he's not contemplating how or what form exactly that agreement's going to take.
I agree entirely with that, my lord, and we will come to some cases in just a moment which do deal with the questions of prior agreements and matters of that kind. The reason I took you to this is two reasons. Firstly, because it's the foundation stone, so unless we see what it says, when we come to the other cases that say, oh, Andrew Bignell said this, it's quite difficult to understand what was being said. And secondly, because it's the case that my learned friends attack by saying that because the later cases stand on Bignell, they're wrong. So, my lord, if we can then come to re Ingle, which is the next case, which your lordships have at page 498. I'm not going to take your lordships to all of the cases. Your lordships have my written case, our written case, which works its way through the cases, and I know your lordships will have read it, but I'm going to take your lordships in the time available to what we say are the key relevant cases. So, re Ingle is at page 498 of your lordships bundle, and it's an 1855 case to do with the 1843 Act. So this is a case, it's a slightly odd case, and it's a case which the Court of Appeal distinguished, but it's a case where what we have is a man who is a defendant, Mr. Nadin, to a claim in relation to some shares. He instructs solicitors and the shares are deposited in court. See that at the start. He then dies, and his widow, Mrs. Nadin, is appointed as his administrator. Mr. Nadin had instructed solicitors, the Ingles. I won't deal with the family difficulties caused by Mr. Ingle number 1 dying and Mr. Ingle number 2 taking over. But what then happens is Mr. Ingle bills Mrs. Nadin for all of the work that has been done. And a deal is done. If we come, your lordships can see that the 276 in bold. In relation to payment of these bills, Mrs. Nadin's not prepared to do so, but she's willing to do so, essentially, if Mr. Ingle will limit his liability, her liability, to the proceeds of the sale of the shares. And eventually, Mr. Ingle agrees to do that. So, in other words, an agreement that Mr. Ingle can use the receipts of the shares when they're sold to pay his bills, provided he doesn't look to Mrs. Ingle for anything over and above that figure. So it could be said, you agree to pay my bills, provided it doesn't exceed a certain sum, being the sum in the value of the shares. There was a problem with this, which is that Mrs. Nadin was illiterate. The shares are in due course sold. Mr. Ingle takes his money and gives Mrs. Nadin the modest balance. It's at the very bottom of the page, just above the 277. Are the figures. Mrs. Nadin then seeks an assessment of his bills. And if we come over the page, we can see at 499 why it was said that Mrs. Nadin shouldn't have the assessment. The second paragraph, where it starts first, taxation is precluded by special agreement and the settlement and retainer of the amount. And then we have a different Master of the Rolls, Sir John Romilly, starting at the third of the way down the page, identifies the questions. First, whether the agreement precludes the taxation of the bills, and if it does not, then secondly, whether it was of sufficient importance to make it necessary to state to the officer on the application for taxation, in which case he would not have granted the order and a special application would have been necessary. That first part is then broken down into two sections. So that's the first bit is the paragraph starting in the first place, the next paragraph. And the sum of the court's decision in relation to that is about 5 lines down. Such an agreement might have been perfectly good if entered between persons who understood their situation, but such is not the case here. So the agreement couldn't stand to prevent taxation. But in any event, the court went on to consider in the next paragraph what was the position in relation to payment. So in other words, if there had been an agreement, was there in any event payment? As to payment, there was none. The solicitor was to retain out of the money to be received by him the amount of his bill. Payment must be either actual payment in money or an agreement by the client on the settlement of accounts between him and his solicitor that the amount shall be retained.
That is reflecting the argument which referred to Bignell,
It is.
although he doesn't refer to Bignell.
He doesn't refer to Bignell, but the argument related to Bignell. And of course, it is my learned friend's case, express case, that this case is decided per incuriam. That is his case. Or my learned friend's case, that is their case. Per incuriam, because it stands on the shoulders of Bignell. We say that is wrong for the reasons we've already given. And no doubt the reasons why my learned friends are so keen to say that this case is per incuriam is because of the effect of it.
Why is it said to be per incuriam? Sorry.
Well, Lord, it's said to be per incuriam because it is based, it is said, by reference to the argument in re Bignell. You can see, my lords, 4 paragraphs from the top, that the argument that was advanced by Mr. Ruppel and Mr. Webb was that there had not been payment, and in re Bignell was.
Well, per incuriam is when you're not referred to a decision and you take and you decide in ignorance of it, the opposite.
Well, my lord, again, I'll let my learned friends expand their case, but as I understand it, they say it's per incuriam because of maybe they should just say it's wrong, but because of a misunderstanding as to re Bignell, in that the court didn't appreciate that re Bignell was what we would now call a Section 71 third-party case, not a Section 70 party chargeable case. That, as I understand it, is my learned friend's argument. But as I say, I'll leave it for him to develop that. No. But we say that's wrong for the reasons I've already ventilated, which is we say Section 71 stands on the shoulders of Section 70. It's, as we've just seen from the re Bignell case, it was all about whether the party chargeable under Section 70 has paid. And if they have, because under Section 71 you're limited to the same order, you can't get to Section 71. The same guillotine, the guillotine isn't stated in Section 71. What is said is the same guillotine comes down because under Section 71 you're limited to the same order that could have been made on the application by the party chargeable.
Well, the Master Earls isn't basing his decision on re Bignell anyway. He's not even referred to it.
Well, my lord, I'm...
Well,
it may have been cited to him, but it doesn't mean he's saying he's bound by. He's just announcing this is the principle.
Well,
actually goes rather further than re Bignell, because there they didn't have to confront any sort of pre-agreement, but here he's directly engaging our problem.
Well, my lord, I agree with all of that.
Well, the curiosity here is that in this case the client had actually agreed the amount of the bills, but because she was illiterate and so on, it wasn't binding on her.
Well, my lords, there's 2 parts to it. So in relation to this, the client had firstly agreed to allow the proceeds to be used, and then the client was provided with 2 bills of costs. We can see that halfway down page 498.
Yes, I mean, it was all done at the same time, wasn't it?
Yes.
So she had the bills.
She had the
if she had not been illiterate and so on, then probably the decision would have gone the other way, because she has agreed the amounts of the bills.
Well, certainly she could be said to have agreed the amounts of the bills, but in any
well, he says so in the judgment. The client, on her part, agreed to the amount of the bills of costs.
Yes.
But it wasn't binding on her because she was illiterate.
So the agreement wasn't binding, but in any event, there was no payment. The solicitor had... So the argument in relation to payment halfway down 499 proceeds on the basis that the solicitor was entitled to retain out of the money to receive by him the amount of his bill.
I'm not sure about that. But I don't think it probably matters from your point of view.
Well, my lord, I rely on the principle, whether it's...
Because if she's agreed the amount of the bill, what's the problem in when the shares are subsequently sold? What's the problem in the solicitor then retaining that amount?
My lord, I would have no issue with that. If
No,
there is a
indeed.
specific agreement to a specific amount in the bill,
Which it was in this
of course the money
case.
can be retained in due course, yes.
Which I think it was in this
Yes.
case, yes.
But, my lord, what I rely on, of course, is the broad statement of principle.
I understand, and that is premised on the fact that on the fact of her illiteracy. So her agreement to the amount of the bill didn't bind her.
Yes, and the mere...
That is true, but he still had to deal, didn't he, or he thought he had to deal with the fact that she had agreed the general principle that the solicitor could retain the amount of the bill out of the money received.
Exactly.
And he was dealing with a payment, could be whether that could be sufficient. When you disregard the fact she'd agreed the particular amounts. And he's saying that isn't good enough because you do have to agree the particular amounts.
Exactly so, and it's the important
I think we may be saying the same thing, because, I mean...
I'm saying the same thing as well. My lords, but the important point we draw from this, and it's always important not to overstate these authorities, but the point we do draw from this is the point that payment must be actual payment in money, and that what is being driven at by the Master of the Rolls, and we say it's entirely consistent with what we saw the promulgator of the 1843 Act say in the previous case, is that what is looked for is either payment in money, in essence, of the bill that's asked for, so in other words, a specified sum of the bill, or the agreement of the client on the settlement of accounts between him and his solicitor. And settlement of accounts, of course, is the term that's been used and has been carried forward. And what settlement of account can, of course, encompass is it can encompass, in the classic way, as with the plumber at your house. The plumber turns up and he gives you the bill and says, you owe me £500, here's the bill. Or you can stand there and you can say to him, well, I'll give you 300. And he says, OK, fine, as long as it's cash or whatever it might be. And you settle the account. But you need the account. You need the demand under the account for the money. And then either the client's agreement to that demand or a deal being done, which arrives at a different specified sum. But that's what you need. Lord, I'm going to move on, if I may, because time is doing that very thing itself. And if I can come then to the next case of the cases that I invite your attention to, it's a case called Re Foss, Bilborough, Plaskett and Foss, which is page 492 of your bundle. It's a High Court Chancery Division decision.
I'm so sorry, what page?
492, my lord, 492.
Thank you. Yeah.
And again, these cases all have their own peculiar facts. But in short, this is now a limited company case where there had been a summons by a liquidator to tax 2 bills out of 3. The taxation of the third had been agreed. So a disputed summons to tax 2 bills by a liquidator in relation to bills delivered to a company that had been subject to a voluntary winding up. Now, what's interesting in relation to the facts of this case, so we can see that on page 494 in terms of the facts, start of the judgment of Mr. Justice Neville. In terms of the facts in relation to this matter, the interesting point is that what had happened, if we come back to page 492, the very bottom of 492, the company had specifically paid money to the solicitors in advance for costs. So they provided the solicitors with money on account for the solicitors to use for their costs. And the solicitors had delivered cash accounts in relation to it, showing how they'd used those monies. So not entirely dissimilar, one might think, from an agreement which the only difference is whether the fund is presently in existence or it's going to come into existence. In this case, there was a fund in existence, which was the monies the solicitors, the company had actually provided, saying you can use this for your costs. In our case, the fund came into existence by virtue of monies provided by the opponent. that the solicitor had been told in advance they could be used for their costs. And then if we come back to 495, the top of that page, objection is taken to taxation on the first and second bills on the ground first of payment, and then secondly, passage of a year.
Sorry, where is that?
Sorry, top of 495.
Oh, yes, I see. I've got it now. Yes, yes. Sorry, thank you.
And then the next full sentence, in my opinion, the solicitors failed to establish payments. The company advanced sums from time to time on account of costs credited to the company in their cash accounts, in which they were debited with, amongst other items, the amount of these three bills of costs. So the company had provided money specifically on account of costs. They had been provided with cash accounts which showed how that money had been used, and it had been transferred for the solicitor's use. But Mr. Justice Neville goes on, in my opinion, where clients have advanced monies on account of costs prior to the delivery of bill and solicitors subsequently deliver a bill and appropriate the money out of their hands in payment, that doesn't amount to payment of the bill within Section 41, so that's the direct predecessor to Section 70 of the Act, at all events where there has been no settlement of account. And so what we take from that is, although the money had been provided and was there to be used for costs, although the solicitor had said this is what we're going to do with it, the absence of settlement of account, the absence of the client being told this is the amount of our bill and we agree to it, meant that this was not payment for the purposes of the Act. It returns to the issue raised by my Lord Leggett earlier, which is, as we progress from Bignold, which was a very general proposition, through the cases dealing with circumstances where it can be said there's some form of prior agreement to the use of monies to pay bills. We say that directly responds to that.
So no authorities are cited.
No authorities are cited on that point, as far as I could see.
Well, West King and Adams is cited. Page
your Lordship's correct.
494.
Well, my Lord, we have West King and Adams in the bundle
Yes.
as well, and we can come to it if it assists.
I mean, that seems to be an authority to the same effect, doesn't it? I mean, it said
Indeed.
by Mr. Palmer, such a retainer of money as took place in this case is not payment in re West King and Adams.
And your Lordships have our position on re West Kings and Adams at paragraphs 45 and 46 of our written case, and unless it will assist in the interest of time, I'm not going to go to it. But that was a case which concerned a sum of money that had been deposited with the solicitors. I think it was £100, specifically deposited with solicitors for use of costs. And it's a case in which, in fact, it might assist just to turn it up very briefly, if your Lordships don't mind me just going to a quick extract from the judgment of it. If your Lordships would be kind enough to come to page 529. In the judgment, and apologies for just diving straight into the judgment, but there's a paragraph on.
Sorry, could you just give me the page again?
Of course, my Lord. It's 529, and that's actually in the middle of the case. So I was shortcutting, if I may.
Certainly.
We get back to Lord Langdale.
We do. So we get back to Re Bignold, we get back to Lord Langdale, we get back to that citation that I've already taken your Lordships to. And then the court says we have been able to find no case in which mere retainer has been treated as payment, so it looks as though they've been doing some consideration themselves. They refer to some other cases, and then at the conclusion of that paragraph, we can find, as we have said, no case in which mere retainer, apart from settlement of accounts, has been treated as payment. And so presumably, one presumes that that was the citation that was then cited in, it would appear to be, in in Re Foss to support the conclusion that the court arrived at in Re Foss. Your Lordships have our written cases on a number of other cases to the same effect, and I've sought in particular, I wanted to take your Lordships to Re Foss, and it's helpful also to mention Re West King, because they do deal with this point about what can be said to be a prior agreement akin to this case. Here are monies, you can use these to pay your costs. But that's not good enough until you send us a bill and we settle that bill with you. That specific bill, you ask us for a specific sum, we either agree that sum or we agree another sum to stand in substitution for it. And until that happens, there is no payment for the purposes of the Act. We say the other cases are to consistent effect, but I'm not going to, unless there are specific issues your Lordship has on them, I'm not going to take your Lordships to those cases at this moment, but we do rely on our written case in relation to them, which I know your Lordships will have read. May I then jump back in my time machine and come forward to the 1974 Act? And can we then come to two cases, the first of which is, one of which I say is more relevant than the other, but two cases which will hopefully assist. The first is Goff and Chivers, decision of the Court of Appeal, page 418 of your Lordship's bundle.
Is this the more relevant one?
This is...
If you're not going to tell us.
That's for us to decide.
If it's not important, perhaps your Lordships are going to tell me in a few moments. But I hope it's the more relevant one. It's page 418, I hope, of your Lordship's bundle. So page 418. So this is Court of Appeal, 1996, dealing with the 74 Act. And I'll take the punch that's probably coming at me from Mr. Ralph, I hope metaphorically, not literally, on the chin immediately, which is, as we see right at the start of the judgment, this appeal is concerned with the interpretation of Section 71 of the Solicitors Act. So it's a Section 71 case, not a Section 70 case. It's a third party seeking to dispute the solicitor's bill, not the party chargeable. And indeed, it is what might be described as one of the classic cases that cause problems with Section 71. So this is a case where Mr. Goff is the beneficiary of an estate of the deceased. There are two executors, not uncommonly, one of whom is a solicitor, and the solicitor, there is a charging clause, so the solicitor is entitled to charge for work that he does as executor. And this is a situation that commonly causes problems when it comes to the solicitor's costs. And the facts are of some importance here because, as I say, this is the case the Court of Appeal relied on. So if we just follow through on page 418, what happens here is Mr. Mogg is the co-trustee. And so Mr. Jordan, who's the solicitor, informs Mr. Mogg that he's received a draft bill at £6,700 and odd pounds. He's also written, which is good modern practice, to the beneficiary solicitors, explaining to them the cost position and indicating he's prepared to limit his cost. He's prepared to accept £5,500 plus VAT. And that sum appears to be the sum that appears in the estate accounts. Mr. Mogg, so he's the client for these purposes, the party chargeable, acknowledges receipt of the letter and confirms that he approves the account. So that's an account stipulating the specific sum. Mr. Goff, unsurprisingly, is the beneficiary, is less happy and queries the bill. And if we can then come on over the page, top of the next page, the first full sentence at the top of that page, on the 24th of March 1993, Chivers and Jordan, so that's the solicitors, Mr. Jordan, drew up a bill totalling the £5,500. So that there's been some prior discussion. It's agreed between the two trustees that the charge will be £5,500, and a bill is produced in that amount, delivered to Mr. Mogg, and paid when the requisite sum was transferred from the Building Society account to the office account of Chivers and Jordan. And then what's important, because we say that this is the part of what was misunderstood by the Court of Appeal, the next paragraph, there was a dispute as to whether Mr. Mogg had consented to the transfer of that funds.
Sorry, where is it?
The second paragraph on that page. At the beginning of his submissions, Mr. Sewell, who appeared on behalf of the beneficiary, queried the question as to whether Mr. Mogg had consented to the transfer of the funds. And that was material because, of course, Mr. Goff's rights were limited to Mr. Mogg's rights. And if Mr. Mogg hadn't consented, the argument would have been there was no payment and therefore no guillotine on Mr. Goff's rights. Now, that point didn't seem to have been taken before the judge, but in the Court of Appeal, there was no doubt that Mr. Mogg approved the transfer from the Building Society account to the office account. So there was an express finding by the Court of Appeal, not merely of delivery of a bill, not merely of figures in a cash account, but express approval. If I can be forgiven for going back to the words I used right at the outset of this, express approval of the specific sum demanded in the bill by transfer of monies, which is what I indicated at the outset we said was the key aspect of what was required for payment that was missing in the Court of Appeal's decision. And there's an express finding here by the Court of Appeal that that was present. The rest of the argument then concerns Mr. Goff's rights, so the third party's rights. And we can see at the very bottom of the page, last sentence on the page, that the opposition to the application for taxation was on the basis that the bill had been delivered and paid. And then if your Lordships will be kind enough to come on to page 421. This is where we can see what went wrong below. So the court below, in the second paragraph on that page, had taken the view, paragraph beginning, I take the view, and they had strong and forceful submissions, that in this type of case, ... it is essential that the beneficiary should not only have knowledge of the amount of the bill, but should also approbate or agree to the amount. So the executor, the party chargeable, had had knowledge of the bill and had approbated or agreed to the amount. But the argument was that the guillotine didn't come down on the third-party beneficiary unless they too had had that and done that. That was the finding below. And that was considered at some length. And I won't take your Lordships all the way through it, but if we come partway down to page 423, having considered some of the authorities, the Court of Appeal, Lord Justice Aldous concluded at halfway down 423, paragraph I believe. So having considered the authorities, it was clear from the extracts he'd read that there was nothing to suggest the payment of the bills that was made by the trustees to Mr. Gosnell in the cases he was looking at was not to be considered a payment within the terms of the Solicitors Act, which was then the relevant act. So the point is being made is the payment for the Solicitors Act was whether it had been paid by the party chargeable. And so the argument being advanced that the same quality of payment was required from the beneficiary was wrong. And then we see the conclusions at 426. And this at 426, the third paragraph beginning having concluded, is the express paragraph which is cited with approval by the Court of Appeal in this case as representing the proper construction of the term payment in the Solicitors Act 1974. Having concluded that the statement of law replied on by the judge from the speech of Bowen J. was obiter, I believe this court should construe section 74 of the Act, so that's the very section we're dealing with, even though this is a third-party case, the important provision is the section 70 provision. The word payment, in my view, should be construed as covering the transfer of money in satisfaction of a bill with the knowledge and consent of the payer. And those are the words that the Court of Appeal says are what payment means. Those are the words that the respondent says are what payment means. And it's done by express reference to this case. But the problem is, what the court has done in this case has expressly said that payment comes not merely because of the delivery of the bill, not merely because of any retention of monies, but because of the express approbation by the executor of the specific sum of a specific bill. And so that dictum once it's seen in its proper context, is not dismissive or destructive of our case. It is wholly consistent with and supportive of our case. To put it more bluntly, it is our case.
Do you rely on what's said in Reed Jackson, which is quoted there?
Well, my Lord, in terms of Reed Jackson, again, it's a case that's dealt with in our written case at paragraphs 54 to 56. We do rely on Reed Jackson. It's not, I have to say, and your Lordships may find this when you come to it, it's not on its facts actually the clearest case to work your way through. But we do rely on that. It's an operation in which two parties take part. It's not really a payment unless the other party knows what's being done and agrees that the sum received in that way. And the important point is the sum received. The agreement to a specific sum shall be used in payment of his debt. It's not, I have to say, Reed Jackson isn't the easiest case, I think, for either side to work its way through if we come to it. And so I'm far from putting it at the forefront of my case.
But that particular passage is relied upon in the case here.
It is. But what I do rely on is what's said at the very final paragraph of that page, because it summarises what was the effect of this case. In the present case, the payer was the trustees. Both of them agreed to the payment of the specific amount, £5,500. The agreement to that specific sum, amounted to payment. And we've seen that from the case. And in my submission, the dictum of Lord Justice Aldous, which is relied on by the Court of Appeal, cannot properly be seen in the context of this case as a dictum which supports the argument that mere retainer.
And the real issue in that case was whether it was the payer or the beneficiary who had to have the requisite knowledge or consent. On its facts, the knowledge and consent of the trustee, the payer, was a consent to the payment from an external account under his control. It wasn't anything to do, it wasn't a case about retention at all. No. It didn't raise the issue whether retention of monies under a pre-agreement authorising retention would constitute a payment.
Well, Lord, absolutely.
It's all about whose knowledge and consent matters.
It's about whose knowledge, but it also, we say it goes to what is required for that knowledge and consent.
Well, yes, but it wasn't dealing with a case in which there was any issues to any doubt that there had been the best possible type of knowledge and consent by Mr. Mogg, who had actually gone along to the Building Society and drawn out the money. My
Lord, absolutely. The issue was whether that same knowledge and consent was required of the beneficiary, or whether it was sufficient that it was provided by the executive. That was the issue. But the particular reason I take it to you is because this case was relied on. This is where, these are the very words the Court of Appeal summarises as being what payment means. Taken from this very case, cited as a dictum with approval. And we say it is a misunderstanding to read these words as saying that what the Court of Appeal was saying here was that there isn't a requirement for approval, because they had expressly found that there was. The only question was whether the beneficiary needed to provide it as well. It's not, I absolutely take Lord Briggs's point, it's not a case about the prior retention point. That's why I took your Lordships to cases such as Refos, which we say does deal specifically with that point about a prior authority to use monies, or why we also took your Lordships to the case of Re-West, which we say is again the analogous situation where you have the position where there is a fund that the solicitors are told that they can use. We've dealt with those points. Lord, I'm overrunning, but I'm overrunning, if I may, with the grace of my learned friend who's indicated that he was content, subject to your Lordship's agreement, that we use the time until 1 o'clock.
Okay.
If your Lordships are content with that,
that's agreed.
Indeed.
Thank you very much indeed.
And I will finish within the next 5 or so minutes, at which point Miss McGonagall will take you up to the lunch gong.
I see. Very well. There was I thinking it was all very short.
Lord, I hope I'm not making it more complicated than it needs to be, because we do say it's actually quite simple. But
you've got one more case, I think.
I have got one more case and then one further brief submission, my Lord. So the one more case I can take you to. Sorry, I've just lost my page. Your Lordship, just give me a moment.
This is the less relevant case, no?
I've rather let myself in for it with that, haven't I? I do apologise. So, my Lords, if we can just come to... sorry, my Lords, if you just give me a moment. I managed to turn over the wrong page. It's the case of Harrison and Tune. It's page 429. So, in fact, it's the very next case in your bundle. I could have just turned the page over and it would have been simpler. Page 429 in your Lordship's bundle. This is another decision of the Court of Appeal, 1987. And so this is a case where, as we will see, monies from property transactions were paid into the solicitor's client account. And then there's a process whereby those costs are agreed by the parties. Now, this case isn't dealing with the question of payment under Section 70. It's dealing with a different question, which is where a party was shut out from a statutory assessment under Section 70. Did the court have an inherent jurisdiction, nevertheless, to order an assessment? And the answer was, no, it didn't, where the bills have been paid. But what is material in relation to it, we say, and which is why I say it's less relevant, but may just assist, and I'll deal with it very shortly. If we come to page 436, so we see at F, there were 10 bills delivered by Mr. Chew to Mr. Harrison over a period. As to payment of the bills, there is then a process described. Each bill at G had been settled on occasions when Mr. Chew received large sums of money representing the purchase price. Mr. Chew disposed that Mr. Harrison had always agreed his bills and agreed them willingly. And then if we go over the page, we can see the process at letter B. Mr. Harrison and Mr. Chew sat down in Mr. Chew's office, prepared a handwritten statement setting out how the monies would be paid out. The details were then agreed at letter C. The statement was typed up. Bill was then produced. The agreed sums was handed to Mr. Harrison in Mr. Chew's office, and then Mr. Chew at letter D, solicitor, would then take the agreed payments out of his firm's client account as set out in the bill agreed and handed to Mr. Harrison. And then at letter E, and of course this wasn't the disputed issue, but nevertheless the court held on these facts, I have no doubt there was a settled account between Mr. Harrison and Mr. Chew on each occasion, and each of the bills was paid by Mr. Harrison, thereby shutting him out from a Solicitor's Act assessment, in that Mr. Chew made transfer of the appropriate sum to the firm's account with the prior agreement and authority of Mr. Harrison and after the relevant bill of costs had been delivered to Mr. Harrison. Now, we say that is, in practical terms, what the Act anticipates. What we do say is modern practice means that that can hopefully be dealt with much more snippily and sharply. I'm not going to say people will send bills by WhatsApp, but they certainly have much more modern ways in which to send bills and to seek the client's approval and engagement. And as we've already indicated, the solicitor has remedies if that's not there. And we say that's wholly consistent with the line of authorities we've seen as to what's expected, in particular the point about the agreement and authority to sums demanded, specified sums demanded in bills.
Did they look at any of the old cases?
Sorry, my lord.
Did they look at any of the old
That's an
cases?
interesting question, to which I don't immediately know the answer. I'm trying to quickly see if they looked at any of the cases we've referred to.
I'm just wondering where Lord Justice Dillon got the settlement of account concept from. It doesn't exactly spring off the page of Section 70. It comes from an understanding of what it's always meant in the earlier cases.
Yes, I'm just quickly looking down the list. I see, in fact, coincidentally enough, Farrell and Alexander was referred to, but of course that's not on that point.
As I understand it, I mean, he's gone into it in some detail, but it's really just setting up the question which they then have to consider, which is whether the court has an inherent jurisdiction to go behind the Act.
I can't see...
Maybe he's just applying his accumulated knowledge.
I wouldn't be at all surprised in the case of Lord Justice Dillon if that wasn't the case.
Well, my Lord, the other thing I can't...
Scholarship.
The other thing I can't say, because I don't have the encyclopedic knowledge that will allow me to do so, no doubt Mr Ralph will, and he'll clear the issue up for me, is whether on page 430 or 431 any of those cases are amongst the many other cases which have been cropped up over the years where these principles have been considered. It may be that they have in some or other of them. In particular, for some reason, Pritchard and Cobden is ringing a bell, but I don't know.
Orsenard, perhaps?
Possibly, my Lord, yes, possibly. But I can't say for sure. But it may well be that one or other of the cases that was cited, but it wasn't a major issue before them. I rely on it as an example of the practice that was in place then, as a practice that can be more easily facilitated now, and as being consistent with the approach that we say applies. Which leaves me, I think, my Lord, subject to any questions from your Lordships, with, I think, about 2 minutes, to come to this point, which is where we say the Court of Appeal went wrong. And of course, this Court's not bound by the Court of Appeal, but it will acknowledge the experience of the Court of Appeal, and in particular, weight a decision of the Master of the Rolls carries, particularly in issues to do with the Solicitors Act of 1974. What we ultimately come to, Lord, is that we say, firstly, the Court of Appeal was wrong to disregard the authorities that we have looked at, which provide a consistent line of authority supportive of our case. And in particular, we say, as we said in our written case, that it was wrong to disregard them by reference simply to the question of whether there was a written retainer or not, and in particular, whether the authorities dealt with the question of an agreement of the type we now see, which is a specific agreement saying that you can in future deduct monies from, pay your costs from monies held on our behalf. We say that not least because, as we've seen going to cases such as Re Foss, that whilst the sort of terms that solicitors have in their retainers nowadays may not be on the same terms as solicitors had some time ago, there are directly analogous positions where the solicitors have been provided with a fund that they've been told that they can use for their costs. But nevertheless, those authorities say that's not good enough unless and until you deliver the bill and seek our approval for a specific sum.
I mean, you presumably say that there's no suggestion in any of the old cases that the deduction from the fund was unauthorised.
Indeed so. That's exactly so. None of those cases say that. They proceed, as you've seen, even in the case of Reingle, where we have the oddity with the agreement that was unenforceable, the dictum appears to proceed on the basis that there was a lawful deduction, but that because the agreement to a specific sum no longer stood, there was no agreement, and therefore no payment. But Lord, for that reason, that's the very case I just touched on. We say the Court of Appeal, at paragraph 3 of its judgment, just for your Lordship, it errs in its analysis of that case. We say at paragraph 37, it errs in its analysis of the case of Foss, because that's another case where we say there's the directly analogous position of monies specifically advanced to be used for payment of cost. Nothing wrong with the deduction, but not good enough to amount to payment. And for the reasons I've just given, we say it errs at paragraph 41 in saying that the dictum in the case we've just looked at of Goff can be taken as supporting the respondent's case when we say on proper analysis it supports our case. So, my Lords, for all of those reasons, and subject to any questions your Lordships have, and subject to the point that my learned friend Ms McGungle is going to address you on shortly now, my Lord, that is the core of our case.
Thank you.
Lords, thank you.
Ms McGungle.
May it please you, Lordships. I'm grateful to my learned friend, Mr Malliou. I have a single point to deal with today, and I hope to do it quickly because I appreciate the luncheon period is approaching.
It's all right, our tummies aren't rumbling yet.
The point that I make starts with our written case and paragraph 81 to 93 of that case, which is page 73 of the core bundle. And effectively, the point that I make is about the practice and the impact on solicitors if we are successful in our core case. You will see from the respondent's argument that they have raised a concern, and also the Court of Appeal raised the concern as to the position that a solicitor is put in if a client ignores communication, so about this issue of knowledge and consent, about settlement of accounts. If a client ignores the communication which seeks to obtain their agreement for the deduction pursuant to a bill, are they left in limbo? Is it ad infinitum? Does the clock stop running? So firstly, I will reiterate what Mr Molyneux said in terms of statute, but I hope to go through it quite quickly. I'll then consider the purpose of the statute, and then we will consider the impact, and particularly the impact in terms of prejudice to the solicitor. So, as Mr Molyneux took you, my lords, to the 1843 Act, which is at page 259 of the core bundle. This was a Consolidation and Amendment Act, as Mr Molyneux has referred you to. And it's section 37, which is at 273 of the core bundle, that I refer you to in the first instance. And quite quickly, it's the bottom of the page. We can see there's a title there that says taxation after 1 month. And what this does, and Mr Molyneux took you to this, what this does is introduces the ability of the solicitor to apply for taxation. And that's our point. So, notwithstanding the fact that the client could ignore communication, after a period of a month, the solicitor has the right to apply for taxation. And that can't go anywhere. That's then reiterated in the 1932 Act. If we could go to page 293 of the core bundle. Now, this was a Consolidation Act, and specifically I refer to page 320 of the bundle, where we can see at section 66, taxation of bills on the application of the party chargeable or the solicitor. And the important point there is exactly as it is within the 1974 Act that concerns us. Paragraph 1 on the application within 1 month of the delivery of the solicitor's bills, so exactly the same as in section 70 subsection 1 of the 1974 Act. Here is the right for the client, but in subsection 2, just as in section 70 subsection 2 of the 1974 Act, we have an application within the period on the application either of the solicitor or the party chargeable. So again, it's the right that's conferred within there that is crucial. Ultimately, the point that I submit...
Can I just understand? I'm just trying to look at the proviso 1. The first 12-month time limit, that seems to bite on the party chargeable, so the
yes.
client, and doesn't seem to catch the solicitor.
No.
Is that right? So
yes.
The solicitor can go at any time?
Yes, after the month's period.
Right.
So effectively after the period within which the client has an opportunity to consider their options.
Mm.
And then we have the Consolidated Act. Page 338 is the applicable section. Section 70. Again, we have the Act with various additions, including the change of words to assessment rather than taxation, as it was previously. We then have, in very similar terms, 71, the client's 12-month period on payment, following payment rather, and then Section 2, the opportunity for the solicitor to make the application subsequent to the period of a month. And our case is that the purpose of this statute provides the clients with a specific statutory right to challenge bills, statutory bills, but it also gives the solicitor, after 1 month, the opportunity to request an assessment to have that bill assessed and ultimately to seek the court's opinion on the reasonableness of the charges sought. So our case is that, notwithstanding the respondent's submissions on this provides an absolute equality of arms, and actually there's an arguable benefit to the solicitor, because if we go over the page to 339, we can see there at section 70, subsection 9, that unless the order was made on the application of the solicitor and the party doesn't attend, and then B, the order for assessment or an order under subsection 10 otherwise provide, the cost shall be paid according to the event. This is to say, if the amount of the bill is reduced by a fifth, the solicitor shall pay the costs, but otherwise the party chargeable shall pay the costs. This is against the backdrop of an assessment on the indemnity basis, where the only issue for the court is the reasonableness of the charges sought. Are they reasonably incurred? Are they reasonable in amount? There's no issue of proportionality here. So arguably, this puts the solicitor in a better position because the client will have to pay the costs of seeking that assessment. And then if the client...
only if he contests it.
If they contest it, but if they don't engage, then you have subsection 10, which allows the court to find special circumstances which could go over and above the normal costs order, in that they can effectively penalise the client for not being willing to engage or ignoring the situation.
So as I understand it, under section 9, subsection 9A,
yes,
if the solicitor turns up on the assessment but the party chargeable doesn't, then the court has its ordinary discretion as to cost.
Yes, yes.
The formula doesn't apply.
Yes, quite.
Yeah.
So, effectively, the important issue here is the impact on this qualification as to what payment means. And as Mr Mallew said, an agreement to a specified sum referable to a bill for payment to take place. And in that regard, what that means is that a bill of cost is rendered which seeks money from damages. You either get the agreement from the client, the solicitor or the client make an application for assessment, and the timetable runs as a result of that. And it's
so if the client doesn't engage, the solicitor has a choice, basically. Either they submit their own bill to assessment, and it might get knocked down a bit, but that way they'll get paid, or they just sit it out and wait, and if time runs out, then they can get paid that way.
Absolutely, absolutely. It's a limitation argument. It's not depriving solicitors of the ability to be paid and have bills assessed. It's just a limitation argument, and it's as simple as that. So, in my submission, there is no prejudice. Mr. Malloy took you to the Hansard before, which is at page 345. And it's a bit impenetrable, actually, but shock horror. At column 415, we can see the meaning behind the original act. And I say the original act, but the original act I refer to, which is the 1843 Act. And it says there, a sentence down from column 415, this bill also provides that the attorney or solicitor may himself be at liberty to refer his own bill for taxation if the client doesn't think fit to do so within a limited time after delivery of the bill. And that's it. That's our case on this point, and it sums it up perfectly in my submission. So, effectively, my point is very simple. This offers clarity to both parties. What we are asking the court to consider is that a client seeks agreement to a specific sum referable to a bill of costs when payment by deduction is in play. It doesn't fetter solicitors' right to assessment. It simply puts parties on an even keel. With knowledge and consent, which is something, as my learned friend Mr. Melly referred to, that the Court of Appeal were keen to look at, going to that judgment at 199 of the bundle, paragraph 4, we can see there the final line. Instead, payment in section 70 is to be construed as including the deduction of fees payable under a statutory bill with the knowledge and consent of the paying client. That's exactly what we're saying. Clarity for both parties, interaction, agreement to a specific sum, and it's as simple as that. My Lords, I'm grateful, unless you have any questions.
No, thank you very much. Adjourn and resumed.